everyone. Today we will discuss about 74th Constitutional Amendment Act of 1992. The 74th Constitutional Amendment Act of 1992 has added a new Part 9A to the Constitution of India. This part is entitled as the Municipalities. It consists of provisions from Article 243P and Article 243ZG. In addition, the Act has also added a new 12th schedule to the Constitution. This schedule contains 18 functional items of municipalities. It deals with Article 243W. The Act gave constitutional status to the municipalities. It has brought them under the purview of justiciable part of the Constitution. In other words, state governments are under constitutional obligation to adopt the new system of municipalities in accordance with the provision of the Act. The Act aims at revitalizing and strengthening the urban government so that they function effectively as units of local government. Now, we will study about the salient features of the 74th Constitutional Amendment Act of 1992. The Act provided for three types of municipalities. A Nagar Panchayat for a transitional area. A transitional area means an area which is in transition from rural area to an urban area. A municipal council for a smaller urban area. A municipal corporation for a larger urban area. But there is an area where municipal services are being provided by industrial establishment, then the governor may specify that area to be an industrial township. In such a case, municipality may not be constituted. The governor has to specify a transitional area, a smaller urban area or a larger urban area, keeping in view the following factors: population of the area, density of the population therein, revenue generated for local administration, percentage of employment in non-agricultural activities, economic importance, such other factors as he/she may deem fit. Now, we will study about the composition of the municipalities. All the members of a municipality shall be elected directly by the people of the municipal area. For this purpose, each municipal area shall be divided into territorial constituencies to be known as wards. The state legislature may provide the manner of election of the chairperson of a municipality. The state legislature may also provide for the representation of the following person in a municipality: persons having special knowledge or experience in municipal administration without the right to vote in the meetings of a municipality. The members of the Lok Sabha and the State Legislative Assembly representing constituencies that comprise wholly or partly the municipal area. The members of the Rajya Sabha and the State Legislative Council registered as electors within the municipal area. The chairpersons of committee other than wards committees. Now we will study about ward committees. There shall be constituted a ward committee consisting of one or more wards within the territorial area of a municipality having the population of 3 lakh or more. The state legislature may make provision with respect to the composition and the territorial area of a wards committee and the manner in which the seats in a ward committee shall be filled. Now we will study about the other committee of the municipalities. In addition to the wards committee, the state legislature is also allowed to make any provisions for the constitution of other committees. The chairpersons of such committee may be made members of the municipality. Now, we will know about the reservation of seats. The Acts provide for the reservation of seats for the scheduled caste and scheduled tribes in every municipality in proportion of their population to the total population in their area. Further, it provides for the reservation of not less than 1/3 of the total number of seats for women, including the number of seats reserved for women belonging to SCs and STs. The state legislature may provide for the manner of reservation of offices of chairpersons for SCs, STs and women. It also make any provision for the reservation of seats in any municipality or offices of chairperson in municipalities in favor of backward classes. The reservation of seats as well as the reservation of offices of chairperson in the municipalities for the scheduled caste and scheduled tribes shall cease to have effect after the expiration of the period specified in Article 334, which is presently 80 years, that is till 2030. Now we will study about the duration of municipalities. The Act provides for a 5-year term of office for every municipality from the date of its first meeting. However, it can be dissolved before the completion of its term. Further, the fresh elections to constitute a municipality shall be completed before the expiry of duration of 5 years, or in case of dissolution before the expiry of 6 months from the date of its dissolution. But when the remainder of the period for which the dissolved municipality would have continued is less than 6 months, it shall not be necessary to hold any election for constituting the new municipality for such period. Moreover, a municipality constituted upon the dissolution of a municipality before the expiration of its duration shall continue only for the remainder of period for which the dissolved municipality would have continued had it not been so dissolved. In other words, a municipality constituted after premature dissolution does not enjoy the full period of 5 years but remains in office only for that period. The Act also makes two more provisions with respect to dissolution. A municipality must be given a reasonable opportunity of being heard before its dissolution. No amendment of any law for the time being in force shall cause dissolution of a municipality before the 5 years term. Now we will know about the disqualifications of the municipalities. A person shall be disqualified for being chosen or being a member of a municipality if he is so qualified under any law for the time being in force for the purpose of elections to the legislature of state concerned or under any law made by the state legislature. However, no person shall be disqualified on the ground that he is less than 25 years of age if he has attained the age of 21 years. Further, all questions of disqualification shall be referred to such authority as the state legislature determines. Now we will know about the State Election Commission. The superintendence, direction and control of the preparation of electoral rolls and the conduct of all elections to the municipalities shall be vested in the State Election Commission. The state legislature may make provision with respect to all matters relating to elections to the municipalities. Now we will study about the powers and functions of the municipalities. The state legislature may endow the municipalities with such powers and authorities as may be necessary to enable them to function as institutions of self-government. Such a scheme may contain provisions for the devolution of powers and responsibilities upon municipalities at the appropriate level with respect to the preparation of plans for economic development and social justice, the implementation of schemes for economic development and social justice as may be entrusted to them, including those in relation to the 18 matters listed in the 12th schedule. Now we will know about the finances of the municipalities. The state legislature may authorize a municipality to levy, collect and appropriate taxes, duties, tolls and fees assigned to municipality, taxes, duties, tolls and fees levied and collected by the state government, provide for making grants in aid to the municipalities from the consolidated fund of the state, and provide for constitution of funds for crediting all money of the municipalities. Now we will study about the Finance Commission of the municipalities. The Finance Commission, which is constituted for the panchayat, shall also for every 5 years review the financial position of municipalities and make recommendations to the governor as the principle that should govern the distribution between the state and the municipalities of the net proceeds of the taxes, duties, tolls and fees levied by the state and allocation of shares amongst the municipalities at all levels. The determination of the taxes, duties, tolls and fees that may be assigned to the municipalities, the grant in aid to the municipalities from the consolidated fund of the state, the measures needed to improve the financial position of the municipalities, any other matter referred to it by the governor in the interest of sound finance of the municipalities. The governor shall place the recommendations of the commission along with the action taken report before the state legislature. The Central Finance Commission shall also suggest the measures needed to augment the consolidated fund of a state to supplement the resources of the municipalities in the state on the basis of the recommendations made by the Finance Commission of the state. Now we will study about the audit of accounts. The state legislature may make provisions with respect to maintenance of accounts by municipalities and the auditing of such accounts. Now, we will know about the applications of 74th Constitutional Amendment Act of 1992 to Union Territories. The provisions of this part are applicable to the Union Territories. However, the President may direct that they would apply to a Union Territory subject to such modifications as he may specify. In exercise of the above power, the President in 2001 directed that the provisions of Article 243J(d) Committee for District Planning and Article 243(j)(e) Committee for Metropolitan Planning shall not apply to the National Capital Territory of Delhi. Now we will know about the exempted areas. The Act does not apply to the scheduled areas and tribal areas in the states. It shall also not affect the functions and powers of Darjeeling Gorkha Hills Council of West Bengal. However, Parliament may extend the provisions of this part to the scheduled areas and the tribal areas subject to the such exceptions and modifications as it may specify. Now, we will study about District Planning Committee. Every state shall constitute at the district level a District Planning Committee to consolidate the plans prepared by the panchayats and the municipalities in the district and to prepare a draft development plan for the district as a whole. The state legislature may make provisions with respect to the following: the composition of such committee, the manner of election of members of such committee, the functions of such committee in relation to the district planning, the manner of election of the chairpersons of such committee. The Act lays down that 4/5 of the members of district planning committee should be elected by the elected members of the district panchayat and the municipalities in the district from amongst themselves. The representation of these members in the committee should be in proportion to the ratio between rural and urban populations in the district. In preparing the draft development plan, a district planning committee shall have regard to matters of common interest between the panchayats and the municipalities, including spatial planning, sharing of water, other physical and natural resources, the integrated development of infrastructure and environmental conservation, and the extent of the and type of available resource, whether financial or otherwise. Further, the committee shall also consult such institutions and organizations as the governor may specify. The chairperson of a district planning committee shall forward the development plan to the state government. Now, we will know about Metropolitan Planning Committee. Every metropolitan area shall have a Metropolitan Planning Committee to prepare a draft development plan. The state legislature may make provisions with respect to the following: the composition of such committee, the manner of election of members of such committee, the representation in such committee of the central government, state government and other organizations, the functions of such committee in relation to the planning and coordination for the metropolitan area, the manner of election of chairpersons of such committee. The Act lays that 2/3 of the members of a metropolitan planning committee should be elected by the elected members of the municipalities and the chairpersons of the panchayats in the metropolitan area from amongst themselves. The representation of these members in the committee should be in proportion to the ratio between the population of the municipalities and the panchayats in that metropolitan area. In preparing the draft development plan, a metropolitan planning committee shall have regard to the plans prepared by the municipalities and the panchayats in the metropolitan area. Matters of common interest between the municipalities and the panchayats, including coordinated spatial planning of the area, sharing of water and other physical and natural resources, the integrated development of infrastructure, environmental conservation. The overall objectives and priorities set by the Government of India and the Government of State, and the extent and nature of investment likely to be made in the metropolitan area by agencies of the Government of India and of the Government of State, and other available resources, whether financial or otherwise. Further, the committee shall also consult such institutions and organizations as the governor may specify. The chairperson of a metropolitan planning committee shall forward the development plan to the state government. Now we will know about the continuance of existing laws and municipalities. All the state laws relating to the municipalities shall continue to be in force until the expiry of 1 year from the commencement of this act. In other words, the state shall have to adopt a new system of municipalities based on this act within the maximum period of 1 year from 1 June 1993, which is the date of commencement of this act. However, all municipalities existing immediately before the commencement of this act shall continue till the expiry of their terms unless dissolved by the state legislature sooner. Now, we will know about bar to interface by courts in electoral matters. The Act bars the interference by courts in the electoral matters of municipalities. It declares that validity of any law relating to delimitation of constituencies or the allotment of seats to such constituencies cannot be questioned in any court. It further lays down that no election to any municipality is to be questioned except by an election petition presented to such authority and in such manner as provided by the state legislature. Now, we will study about 12th schedule. It contains the following 18 functional items placed within the purview of municipalities. They are urban planning including town planning, regulation of land use and construction of buildings, planning for economic and social development, roads and bridges, water supply for domestic, industrial and commercial purposes, public health, sanitation, conservancies and solid waste management. Fire services, urban forestry, protection of the environment and promotion of ecological aspects, safeguarding the interest of weaker section of society including handicapped and mentally retarded, slum improvement and upgradation, urban poverty alleviation, provisions of urban amenities and facilities such as parks, gardens and playgrounds, promotion of cultural, educational and aesthetic aspects, burials and burial grounds, cremations and cremation grounds and crematoriums. Cattle ponds, prevention of cruelty to animals, vital statistics including registration of birth and deaths, public amenities including street lighting, parking lots, bus stops and public conveniences, and regulation of slaughterhouses and tanneries. Thank you and have a nice day.